Hello dear students, welcome to IAS Viewpoint, the point of success. Today I would like to explain two simple doctrines or concepts. They are procedure established by law and due process of law. I would like to explain especially to the students who do not understand these two terms and what exactly is the difference between these two terms. This session is very basic in nature and it would be in very simple language so that the student understands these two terms. If you already know these two terms, you need not watch this video. All right. First, where do we come across these two words in our Indian Constitution? Due process of law. This doctrine is nowhere specified clearly in the Constitution. However, the doctrine procedure established by law, it is very clearly stated in Article 21 of the Constitution. What does Article 21 speak of? Actually, it talks about protection of life and personal liberty. So it clearly says no person shall deprive of his life or personal liberty except according to the procedure established by law. That means if there is a procedure established by law, individuals' personal liberty and individuals' life may be taken away. There is no protection for individual's life and personal liberty if procedure established by law is followed. In simple words, I will try and explain what it means. First and foremost, there should be a law. There should be a legislation passed by the competent authority. What do you mean by a legislation by the competent authority? In the Constitution, we have under Schedule 7, three heads: union list, state list, concurrent list. And the Constitution has very clearly distributed the legislative making powers. So we have some subjects under the central list, we have some subjects under the state list, and we have some subjects under the concurrent list, and residuary is given to the center. So a law should have been legislated by the appropriate authority by following the appropriate laid down lawmaking procedures. That's the first point. Number two, there should be procedures in place based on that law. For example, I'll give you an example to make this concept clear. Let us take the example of paying the electricity bill. Suppose if an individual does not pay the electricity bill after the due date, for example, if the electricity bill is generated on the 1st of the month and the person is supposed to pay the electricity bill by 17th of the same month, and that is the law made. And if that person does not pay that electricity bill, he shall be imprisoned for 3 months. That is the law. Now, it is just for the example, just to make you to understand. What happens? That is, let us assume this law is enacted properly, appropriately, following all the procedures, and there is a competent authority to legislate, and the competent authority has legislated, made that law. Now, there should be a set of rules and regulations, a set of guidelines to be followed. A procedure should be there. How to arrest that person, how to approach that person, how is the bill to be generated, and what is the mode of contacting that person. Is there any kind of intimation, and is there any kind of regulation in place? Whatever. All these procedures should be established in taking away the freedom of that individual if he or she does not pay the electricity bill. Clear? That is point 2. If a person is put in the prison for not paying the bill by the executive authority, and the authority has very clearly followed the procedure, then the court, if the court follows the principle of procedure established by law, if that in the judiciary or the law of the land or the country follows the principle procedure established by law, then the court says, yes, the electricity department has followed, there is a law towards that end, and the department has followed all the established procedures. Hence, you may imprison that person for 3 months as prescribed in the law. That is what it means by the procedure established by law. Here you can observe 2 things. One is the judiciary, the courts cannot prevent the legislature's encroachment upon the individual's freedom or life. If there is a law and if there are procedures, the person's life can be taken away. The person's freedom can be taken away. Then what does courts do with regard to this procedure established by law? Courts can just protect the individual from the tyranny of the executive authority. There is an executive authority which implements the law. The courts can say, have you followed the procedures properly while implementing that law? Here, a person is protected from the authoritarian approach of the executive authority only. It does not protect the legislature's dictatorship, the legislature's authoritarianism. Here, there is a possibility for a set of people, that is the ruling political class, who can manipulate the things, who can be unjust, who can be inarbitrary, who cannot be fair as well. These are the disadvantages of the procedure established by law. Now, let us move to the second concept, due process of law. What do you understand by due process of law? Here, I would like to explain with a simple Venn diagram. Let's say this one. This is procedure established by law, and this would be due process of law. So it is not a very scientific diagram, just to make you to understand these two the differences. That means procedure established by law is included in the due process of law. Understand, this procedure established is well within the due process of law. And what are the other things? What is this area? What are the other things which due process of law talks about? Along with the procedure established by law, it also checks whether it is just, fair. Is it, for example, if the punishment is for not paying 800 rupees of electricity bill, if you are fined with 10,000 or 20,000 rupees, it is really not just and fair. Understand? It is arbitrary. What is arbitrary? Irrational. It is something which is done at the whims and fancies of certain class of people or politicians or whatever. So they will check, is does the individual has to incur 10,000 rupees of fine for not paying the electricity bill of 800 rupees? Is it really just? Is it really fair? Or do they have to go for, let's say, 100 rupees or 200 rupees of late fee? So the court checks, is it fair? Is it just? Or is it unarbitrary? And this also includes the respect for legal rights. There are established legal rights within the country or within the system. There are fundamental rights. There are a certain very important rules for the existence, for the survival of the individual. All those rules legally provided to the citizen, to the individuals, have to be respected. That is another area which is included in the due process of law. Now, we can categorize this into procedural due process, substantive due process of law. What is the meaning of procedural due process? Let us take the same example. In our example, electricity bill. We will check under the procedural due process, are the procedures just and fair? Let us say, if after 17 days, if the person doesn't pay, straight away go and take him and imprison him. Then there is something missing in that procedure. What is that? The natural justice. Because we never know what happened to that person. We should hear what is the condition of that person. Was he affected by COVID-19, or someone has died in his family, or is he undergoing some trials and tribulations such a way that he is not in a position to pay? So all these things have to be checked, whether these procedures are being followed based on the principle of justice, natural justice. Are they fair? Are they rational? Are they logical? Are they reasonable? Are they unarbitrary? These have to be checked with regard to the procedures being followed while implementing the law. Is this point clear? That is the procedural due process. What is substantive due process? The substantive due process includes not just the procedures which are checked by the judiciary, even the motive of the law is checked. Even the purpose of the legislation is checked. If you go to the Venn diagram, if you think it is a procedure established by law, and these things you will have procedural due process, and higher one would be substantive due process. Substantive due process would include even testing the reasonability of the law. For example, in our own example, is it required, is this law to punish the people if they don't pay the electricity bill well within the time? What is the purpose of that law? What does this law wants to teach the citizens? Does this law teach the citizens discipline, or is there any other purpose to be achieved? Is that purpose, is that end rational? Not just the means, the procedures, is that end rational? Is it really following all the legal principles? All these have to be tested, checked by the judiciary if they follow the principle of due process of law. All right, these are the two concepts which need to be clearly understood. Now, for if you go a bit of technicalities or knowledge of the concept is concerned, you can say procedure established by law is of British origin. It is originated in the United Kingdom. And with regard to due process of law, it was established in the United States of America. For academic purpose, we will consider due process of law, the place of origin or place of establishment, the United States of America. However, you can find the history roots, even due process of law, to clause 39 of the Magna Carta of year 1215. It was just an agreement. What is Magna Carta? You all know. It's a simple agreement between King John of England and the citizens that their rights shall not be deprived, and on those grounds some kind of agreement was made that was known as Magna Carta in 1215. Let's not get into the details, that's a different topic. There, under clause 39, the idea of due process of law is talked about. However, the British did not follow that for various other reasons, like unwritten constitution, and here America follows the written constitution, and the later on developments all indicate the U.S.A. following the due process of law. That's just some kind of historical details. And then, while when we think of, or when we go back to our Constituent Assembly discussions and debates, and if you look at the reason why our constitutional framers preferred procedure established by law, we say, it is said in the history, there were a lot of discussions. There were so many people in the Constituent Assembly and stalwarts in the drafting committee. They all wanted, not all, sorry, some of them wanted due process of law to be placed. Even Dr. B.R. Ambedkar, in his discussions, he said he was also, initially he was for due process of law, and he was weighing the pros and cons of due process of law as well as the procedure established by law, and then he left it to the voting pattern or to the assembly itself, Constituent Assembly, to finalize the stuff. But there was one IAS at that time, ICS officer, civil service officer, B.N. Rao. He was also the constitutional advisor for the committee, drafting committee. He had discussion with the then Justice, not the Chief Justice, Justice of the United States of America. I think his name Frankfurter. Yeah. at that time, he advised Frankfurter, he advised B.N. Rao that please do not include due process of law in your constitution. You have been following, or more or less you were under the British and you were following that system. Go with that system, because we have at that time, as per one of the estimates, around 50% of the cases were based on due process of law, and it was really hectic for the judiciary to take care of that. And you are still a growing up democracy with all these organs of the democracy or government. So better you go for procedure established by law. And one other reason what Justice Frankfurter shared with B.N. Rao is that probably it takes away the democratic authority, or rather the powers vested in the legislature. It is usurping of powers by the judiciary. Hence you may go with the procedure established by law. Then later on, the assembly, the constituent assembly, preferred procedure established by law to due process of law in our Indian constitution, which was explicitly given in Article 21. And what is the status of these principles in India at present? Initially in 1950, there is an A.K. Gopalan case. He was a communist member, where he was detained under Prevention of Detention Act, and he was served under Prevention of Detention Act. Then he approached the court under Article 32, a writ petition, stating that the Articles 14, 19, 21 and 22, these articles, the rights given through these articles were affected to him. On those grounds, he approached the judiciary. However, the court stuck to the principle of procedure established by law. According to the law, there are these things, so you can be arrested. The law says you can be arrested. There are procedures to be arrested. You can be arrested. And it also out of that law, we should understand one point, that it did not link Article 14, 19, 21, 22, all those articles. It has de-linked all those articles. Each article has to be looked separately. That is what A.K. Gopalan case talks about with regard to these two principles. Yes, it upheld, A.K. Gopalan case upheld the principle of procedure established by law. In India, we follow this system. If there is a law to take away your personal liberty, that liberty can be taken away, and hence it is okay to arrest you under Prevention of Detention Act. However, there was a greater change in Menaka Gandhi case of 1978. Let us not get into the details of that case. That's an entirely a different topic, a different session altogether. But in this case, Menaka Gandhi was supposed to go abroad, and her passport was impounded, and she moved the Supreme Court, stating that her rights are taken away, the rights provided by Articles 14, 19, 21, and she moved a writ petition under Article 32. In that judgment, the court moved from the principle of procedure established by law to due process of law. It said, whatever the procedures established, there should be just, fair, they should not be irrational, there shouldn't be the aspect of arbitrary nature and it should not be oppressive and repressive. So this judgment was really a landmark judgment which needs to be discussed separately. However, what happened in our Indian judicial system is that we have moved from procedure established by law to due process of law. Clear? Now the question arises, are we same with the United States of America, which follows the due process of law? A clear answer is, principally we say no. What happens in reality is different. Let's not go for what is happening, how courts are interfering or whatever. That needs to be your answer for the mains questions. Okay, but technically we are not same as the United States of America in terms of due process of law. There, substantive due process of law is followed in the United States of America. We follow the procedural due process of law. We have explained these two terms. We follow procedural due process of law. If the procedure is unjust, unfair, irrational, the court protects. The judiciary does not enter into the domain of questioning the motive of the legislation, the motive of the law. So that is the difference between the United States of America following the due process of law and we following the due process of law. This is in general the understanding of these two concepts. I hope I have cleared all your doubts. If you still have any doubts, please do comment in the comment section. We will try and clarify. And dear students, I have been in touch with the teaching field for about 2 decades. Now I intend to start my own YouTube channel and my own venue for helping students. So I request you to support me by subscribing to my channel if you believe that it has helped you a lot, or at least it has helped you a bit. And please do share our channel to good number of students who are in need of it, and all of your friends and people who know that who are preparing for UPSC civil services and state civil services. And please do like this session. If you have really liked this session, we will use it as a constructive criticism or an analysis and improve upon it. Thank you.